If you own your home and you are over 60, there are 5 documents that can decide whether your family protects your house or watches it get trapped in court, frozen by banks, delayed by hospitals, and exposed to taxes that could have been avoided. And the frightening part is this: most people do not find out these documents are missing while life is calm. They find out after a stroke, after a fall, after a hospital call at 2 in the morning, after a daughter walks into a bank and hears the words, "I'm sorry, you don't have legal authority." I have seen that moment break families, not because the parents were careless, not because the children did not care, but because everyone assumed love was enough, and legally, it was not. Imagine a 72-year-old homeowner. He has lived in the same house for 31 years. He paid off the mortgage. He raised his children there. He fixed the fence himself. He planted the trees in the backyard. Every room has a memory. Then one morning, he suffers a stroke. He survives, but he cannot speak clearly. He cannot sign his name. He cannot make financial decisions. His daughter rushes to the bank to pay his property taxes before the deadline. She knows the account. She knows the house. She knows what her father would want. But the bank does not care what she knows. The bank asks one question: "Do you have legal authority?" She does not. So the bills keep coming. The property taxes sit unpaid. The insurance notice arrives. The house needs repairs. But nobody can sign. Nobody can access the account. Nobody can refinance. Nobody can sell. Nobody can legally protect the home he spent his whole life paying for. That is the part people miss. A home is not protected just because it is paid off. A home is not protected just because your family knows your wishes. A home is protected when the right documents are in place before the crisis. I learned that the hard way many years ago while helping families after retirement. I saw responsible people lose control of their homes for one reason: they waited too long to put their wishes on paper. So today, I want to walk through the 5 documents every homeowner over 60 should have filed, reviewed, and shared with the right people. This is based on the same core issue in the attached script. Homeowners over 60 can face serious legal, financial, medical, and tax problems if key documents are missing before incapacity or death. And document number 5 may be the one that surprises you most. Because one wrong decision with your home while you are alive can cost your children hundreds of thousands of dollars in capital gains taxes later. Most families never see that trap coming. Let me tell you about a man I will call Robert. He was 67 years old, retired electrician, lived in Ohio, owned his home free and clear, no mortgage, a modest pension, a Social Security check, a small savings account, nothing fancy. But he was proud of that house. He had earned every nail in it. At Thanksgiving dinner, he told his 2 grown children what he wanted. His daughter Karen would get the house because she lived nearby. His son David would receive the savings account. Simple. Fair. Everyone nodded. Everyone understood. And that was the problem. They understood it emotionally, but not legally. Robert never signed a will. He never filed a durable power of attorney. He never created a transfer on death deed. He never put the home into a trust. He figured, "My kids know what I want." A lot of good parents say that, and it sounds reasonable, until something goes wrong. In early 2025, Robert had a serious fall. He hit his head. He developed a brain bleed. He could no longer make decisions clearly. Karen tried to pay his property taxes. The bank turned her away. She called Social Security. They would not speak with her. She tried to arrange repairs so the home would be safe if he returned from rehab. She could not sign the contracts. Then David hired a lawyer. He petitioned the court for guardianship. Now Karen and David were no longer just siblings. They were 2 people on opposite sides of a legal process. The house sat vacant for nearly a year. Taxes went unpaid. A lien was placed on the property. Legal fees started eating away at the family. That home was almost lost. Not because Robert failed as a father, not because he failed as a homeowner, but because 5 documents were missing. The first document is a durable financial power of attorney. This may be the most important document for any homeowner over 60. A durable financial power of attorney lets someone you trust handle financial matters if you become unable to act for yourself. That person may be your spouse, your son, your daughter, a trusted relative, a close friend. But the key is that you choose them before the emergency. They can pay your mortgage, They can handle property taxes. They can manage bank accounts. They can deal with insurance. They can sign necessary documents. They may even be able to sell or refinance the home if that becomes necessary. But the word durable matters. A regular power of attorney may stop working once you become incapacitated, and that is exactly when your family needs it most. A durable power of attorney is designed to continue after incapacity. That is why it matters so much. Here is the trap. Many older homeowners believe a spouse or adult child can automatically step in. That is not always true. A bank does not unlock an account because a daughter says, "I'm his child." A mortgage company does not accept instructions because a son says, "Mom trusted me." A county office does not transfer authority because the family agrees. Financial institutions need legal paperwork. Without it, the family may need to go to court. That can mean guardianship, conservatorship, hearings, legal fees, public records, delays, and sometimes family conflict that never fully heals. I have watched families spend months fighting for authority their parent could have given them in one afternoon. That is what makes this so painful. The document is simple compared to the crisis it prevents, but it only works if it exists before the crisis. The second document is a last will and testament with specific home provisions. A will tells the world what should happen to your property after you die, and if you own a home, the will must speak clearly about that home. Not vaguely, not casually, clearly. Who receives the house? Should it be sold? Should one child have the option to buy out the others? Should the proceeds be divided? What happens if the person you named dies before you? These questions feel uncomfortable, but silence is worse. Many seniors believe that telling the family is enough. It is not. A conversation at Thanksgiving is not a will. A promise made in the kitchen is not a legal transfer. A handwritten note in a drawer may not be enough either, depending on state law. Without a valid will, your home passes according to your state's intestacy laws. That means the state uses its own formula, not your memory, not your family conversation, not what you meant. And that formula may send part of your home to someone you never intended. It may divide ownership among several heirs. It may create what people call a tangled title. That is when someone may live in the home, maintain the home, and believe the home is theirs, but legally, the title is unclear. And when title is unclear, everything becomes harder. They may not be able to sell it. They may not be able to refinance it. They may struggle to insure it. They may not qualify for repair programs. They may not even be able to prove ownership cleanly. Probate can also become expensive. It can take months, sometimes more than a year. Legal fees can drain money the family expected to use for repairs, taxes, or care. And the sad part is that many of these problems start with one sentence. "We all know what Dad wanted." Maybe they do, but the court needs more than memory. The third document is a transfer on death deed, or a revocable living trust. This is where many homeowners over 60 start paying attention, because this document can help your home avoid probate. A transfer on death deed, sometimes called a TOD deed, allows you to name who receives your home after you die. You keep control while you are alive. You can still live there. You can still sell it. You can still change your mind. But after your death, the home can transfer directly to the person you named, without the same long probate process. Not every state allows transfer on death deeds, but many do. And where they are available, they can be a powerful tool. If your state does not allow one, a revocable living trust may be another option. A living trust allows you to place your home into a trust that you control during your lifetime. You can be your own trustee. You still manage the home, but if you become incapacitated or pass away, a successor trustee you chose can step in. That can help avoid court delays. It can help keep the home protected. It can help the family move faster. But there is a serious mistake people make with trusts. They create the trust. They pay the lawyer. They put the binder on a shelf, and they think they are done. They are not. A trust does not protect a home unless the home is actually transferred into the trust. That means the title must be changed properly. If you create a trust but never retitle the house into that trust, your home may still go through probate. That is one of the most heartbreaking mistakes, because the family thinks the planning was done. Then they discover the most important step was skipped. You also need to be careful with anyone selling trust packages too aggressively. Some people use fear to sell expensive documents seniors may not need. A trust can be useful, but it should be created with proper legal advice, not pressure, not a dinner seminar promise, not someone rushing you into signatures. And there is another issue homeowners over 60 must understand: Medicaid estate recovery. If Medicaid pays for certain long-term care services after age 55, the state may seek recovery from your estate after death. In some cases, liens may become part of the discussion. There are protections for certain surviving family members, such as a spouse or disabled child, but the rules are serious and state-specific. That is why transferring a home without advice can be dangerous. You may think you are protecting the house, but you may create tax, Medicaid, or ownership problems you never intended. The fourth document is an advance healthcare directive. This one protects your medical wishes, not your bank account, not your home title, your body, your voice, your dignity. An advance healthcare directive usually has two parts. The first part names a healthcare proxy, that is, the person who can make medical decisions if you cannot speak for yourself. The second part is often called a living will. That explains what treatments you want or do not want if your life is seriously threatened. Breathing machines, feeding tubes, resuscitation, dialysis, end-of-life decisions, organ donation. These are not easy topics. Nobody enjoys talking about them at the dinner table. But I have seen what happens when families do not talk about them. One child says, "Mom would want everything done." Another says, "No, she told me she never wanted machines." A spouse is overwhelmed. A doctor needs a decision. The family is grieving and guessing at the same time. That is a terrible burden, and it can divide people who love each other. A financial power of attorney does not automatically cover medical decisions. That is a major misconception. You need a separate healthcare directive, and once you have it, do not hide it in a drawer where nobody can find it. Give copies to your doctor. Give one to your healthcare proxy. Give one to trusted family. Make sure the hospital can access it if needed. A document nobody can find during an emergency might as well not exist. Medicare may also cover advanced care planning as part of a wellness visit. That means you may be able to discuss these wishes with your doctor without an added cost during that visit. Ask about it. Bring it up. Do not wait for a hospital hallway conversation. Those are the worst places to make decisions that should have been made calmly. The fifth document is the homestead exemption, or senior property tax exemption application. This is the one that can save you money every year. Many states, counties, and cities offer homestead exemptions. Some offer senior property tax exemptions. Some offer tax freezes. Some reduce the taxable value of your home. Some limit how much your tax bill can rise. These programs can be extremely valuable for retirees on fixed incomes. But here's the part too many people miss. They are usually not automatic. You must apply. You may need to renew. You may need to prove age, residency, income, disability, or ownership. And if you miss the deadline, you may pay full price. One missed form can cost hundreds or thousands of dollars. 10 missed years can cost far more. I have known people who complained every year about property taxes and never realized they qualified for relief. Not because they were irresponsible, because nobody told them clearly. The application sat on a county website. The deadline passed quietly. The bill came due, and they paid more than they needed to. If you are over 60 and you own your home, check your county assessor's office. Ask about homestead exemptions. Ask about senior exemptions. Ask about property tax freezes. Ask whether renewal is required. Ask what the deadline is. Put that date somewhere you will not miss it. Now let me come to the hidden tax trap. This may be the most expensive mistake in the entire conversation. Many parents think they should deed the home to a child while they are still alive. They think it makes things simple. They think it avoids probate. They think they are protecting the house. But gifting a home during life can create a massive capital gains problem. Here is the simple version. If you bought your home 40 years ago for $50,000 and today it is worth $400,000, that gain matters. If you gift the house to your child while you are alive, your child may receive your original cost basis. That means their basis could still be $50,000. If they later sell the home for $400,000, they may owe capital gains tax on $350,000. That can be a very expensive gift. But if your child inherits the home after your death, the basis may step up to the fair market value at the date of death. So if the home is worth $400,000 when inherited, their basis may become $400,000. If they sell it for $400,000, there may be little or no capital gain. That one difference can save a family an enormous amount of money. Gift versus inheritance. It sounds small. It is not. It can be the difference between preserving wealth and handing a painful amount to the IRS. That does not mean nobody should ever transfer a home during life. Every situation is different. There may be Medicaid planning issues, family caregiving issues, asset protection concerns, state laws, trust strategies. But the point is simple. Do not deed your home to anyone without talking to a qualified attorney and tax professional first. A signature made in fear can cost your children more than probate ever would. So now you know the 5 documents. Durable financial power of attorney. Last will and testament with clear home provisions. Transfer on death deed or revocable living trust. Advance healthcare directive. Homestead or senior property tax exemption application. But knowing the list does not protect you. Action does. The first thing to do is gather what you already have. Sit down at the kitchen table. Pull out your home papers, your deed, your mortgage payoff letter if you have one, your will, your power of attorney, your medical directive, your tax bill, your exemption paperwork. Make a simple list. What do you have? What is missing? What is outdated? Who has copies? If you are missing even one of these documents, that is a gap, and gaps are where families get hurt. The second thing is to share the documents with the right people. A power of attorney sitting in a drawer may not help if the bank refuses to accept it during a crisis. Some banks want to review these forms ahead of time. Do that while you are well. Your healthcare directive should be with your doctor and your chosen medical decision maker. Your family should know where the originals are. Your executor or trustee should know whom to call. The people you trust should not have to search through boxes while you are in a hospital bed. The third thing is to review everything once a year. Life changes. People die. People move. Relationships change. Laws change. Your chosen agent 5 years ago may not be the right person today. Your will may have been written before a divorce, before a death, before a grandchild, before a move, before your home changed in value. Set one date every year. Your birthday, New Year's Day, the first Sunday in January. Any date you will remember. Review the documents. Confirm the names. Confirm the addresses. Confirm the property tax exemption. Confirm the people who have copies. That habit can save your family from chaos later. And please understand this. The government will not always remind you. The bank will not always warn you. The county may not chase you down about an exemption. The hospital may not know your wishes. The court will not say, "We know what your father meant." The system runs on documents, not assumptions, not promises, not memories. I know that sounds cold, but it is better to face that truth now than during a crisis. Because the 5 documents we discussed do not work after the emergency has already frozen everything. They work because they were prepared before the emergency, before the stroke, before the fall, before the hospital call, before the property tax deadline, before the family disagreement, before someone says, "I'm sorry, you have no authority." Your home may be the largest thing you ever built, not just financially, emotionally. It may hold your marriage, your children, your work, your sacrifices, your quiet victories. Do not leave that home exposed because the paperwork felt uncomfortable. Do not let a missing signature decide what happens to decades of effort. And do not assume your family can fix later what you can protect now. Because later is when things get expensive. Later is when people are grieving. Later is when courts get involved. Later is when siblings argue. Later is when taxes appear. Later is when the house sits empty while everyone waits for permission. A paid-off home still needs protection. A loving family still needs authority. A clear wish still needs a legal document. That is the truth I wish more homeowners over 60 heard before the crisis came. Because the house you spent your life building should not be lost to confusion, court delays, missing forms, or one wrong transfer. It should pass with dignity. It should be protected with care. And the people you love should not have to fight the system just to honor what you already wanted.